I am the president. My name is Nelson Johnson. We're very excited to present this discussion. This is going to be on the role of state judges, the federal courts, and judicial supremacy. We're going to focus as the main topic of this discussion, Roy Moore and his 2 removals in the judiciary. I would just like to give a short introduction to our panelists today. We have Judge Pryor, who is going to be moderating the discussion, Josh Blackman, who's going to be giving the possibly didn't violate the Constitution side, and we've got our very own Judge Carroll, who's going to present the opposing view. Judge Pryor serves on the U.S. Court of Appeals for the 11th Circuit, and he is the acting chair of the U.S. Sentencing Commission. He served as the Attorney General of Alabama from 1997 to 2004, and at the time of his election, he was the youngest Attorney General serving in the nation. He also was the lead prosecutor against Roy Moore on his first removal. Josh is an associate professor of law at South Texas College in Houston. He specializes in constitutional law, the U.S. Supreme Court, and how law intersects with technology. He also has the Fantasy SCOTUS, which is basically a fantasy league for the Supreme Court decisions. And Judge John Carroll is a professor at law at Cumberland. He was the prior dean at Cumberland. His JD is from Cumberland, and he graduated with an LLM from Harvard. He was the lead prosecutor on the second removal of Roy Moore. So, at this point, I will turn it over to Judge Pryor and get started.
Okay, we're going to start off with about a 10-minute opening for each of the 2 speakers. Josh has a PowerPoint presentation. So
actually a bit of a pop quiz.
A pop quiz. So he'll start. For clarification, though, I was the only prosecutor when Roy Moore was removed from office. It took a unanimous vote of the Court of the Judiciary to remove him from office. Judge Carroll, Court of the Judiciary, unanimously voted to suspend him without pay. Technical difference.
Because you couldn't appeal the latter. Anyway, thank you so much. It's great to be back here. You're very fortunate here in Birmingham. Such 2 great jurists as Judge Pryor and Judge Carroll. We've had so much experience with this question of Roy Moore. Now, I don't think he's here. I haven't seen him at the shopping mall or anything, so I don't think he's here at the moment. But I will try to be as neutral as I can. And again, I'm not a Roy Moore fan. I don't agree with virtually anything he says, except when it comes to Supremacy Clause. I think he has something to talk about. So let's make these points. So let's start by actually reading Article 6 of the Constitution. Every year for the first day of con law, I read to my students the entire Constitution, every word of it. You get only 1 article. Often you hear about the Supremacy Clause, but there are actually a few clauses. I want to do them one at a time. So first it says, this Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land. Okay, next. And the judges in every state shall be bound thereby referring back to the supreme law of the land. Anything in the constitution of laws of any state to the contrary notwithstanding. Third, the senators and representatives before mentioned in Article 1, and the members of the several state legislatures, and all executive and judicial officers, both of the United States and the several states, shall be bound by oath or affirmation to support this Constitution. Now, I'm a textualist. Justice Kagan tells us we're all textualists now, so let's be textualists for a minute. Don't think about the Supreme Court. Just think about the text. We'll get to the Supreme Court a little bit later. Let's do a little bit of a pop quiz. Okay? We'll do a show of hands. The first question. Under Article 6 of the Constitution, the decisions of the Supreme Court are the supreme law of the land. Who says it's true? False? Did one hand go up for the true?
I'm true.
Okay. So everyone true. So true? False. Everyone else. The wisdom of the crowd prevails. It's very common to say the court's decisions are the supreme law of the land. In fact, the Supreme Court said that in a very famous case called Cooper
versus Aaron, decided in the civil rights era, a very tumultuous time. But if you actually look at the text of the Constitution, which is where I always start, it says nothing about Supreme Court's decisions being supreme law of the land. What's supreme law of the land? The Constitution and laws of the United States, as well as statutes thereof. Okay, so the court's decisions are not referenced anywhere in the Supremacy Clause. Okay, that's the first question. The second one, a question near and dear to Judge Pryor's heart. Under Article 6 of the Constitution, the Supreme Court can strike down a law. Strike down a law. Who says true? Ooh, false. Okay, that's correct. It's a very common expression, which I'm guilty of myself, guilty as charged. I said in the car right over here, to say that the court strikes down law. But courts don't have an eraser, what Jonathan Mitchell calls a writ of erasure, right? Courts can't go into statute books and take a knife and cut out a statute. Courts can say that this statute is not consistent with the higher law, which is the Constitution, but they can't strike a law down. I'll give you an easy example. What if a 5-4 majority today says this law is unconstitutional, and then a year later a 5 majority says, no, that law is fine? Does the law suddenly get resurrected? No, it was always where it was, but just based on the current legal order, there was an interpretation that varied. And this happens in the legal tender cases, where one year the Supreme Court struck down a law requiring paper money as legal tender, and then next year, after a couple of justices were appointed, they flipped the other way. Okay, so far so good. You guys are doing very well. Question number 3, a little bit harder. Under Article 6 of the Constitution, the decisions of the Supreme Court are binding on all states, whether they participated in a case or not. True or false? Okay, a couple true. Okay, good. False. Okay, and a lot of people didn't raise their hand. I think the answer here is false, and we'll probably disagree on this during the debate. The Supreme Court is a court like any other. They have jurisdiction of the parties before it. Jones sues Smith. We learned in Cipro, they have raised judicata between Jones and Smith. If Mary was not a party to that case, then she's not bound by the judgment. Wait a minute, John, it's a Supreme Court, doesn't it bind everyone? Not exactly. And to use an example, Brown versus Board of Education considered the segregation laws of Kansas, Delaware, Virginia, one other I'm drawing a blank on. Anyway, there were 4 states. It was Kansas, Delaware, Virginia, and also DC. That was the companion case, right? Did Brown immediately tell every state that they had to desegregate immediately? No, in fact, that's not what happened. You had a lot of follow-up litigation, mostly in the 11th, now formerly the 5th Circuit, where you had district court judges who actually had to preside over desegregation. It was understood that states that were not party to Brown were not bound by that judgment. We'll talk about that in the context of Mr. Moore. Next, under Article 6 of the Constitution, a state Supreme Court is bound by the judgment of a federal district court. True or false? Who thinks true? False? You guys are pretty good. I have to admit, maybe this is Alabama, maybe there's something about the state, and you guys get a good education at Samford, but
It's a really good law school.
it's a really good law school. Why should you ask this question? Because of course, a federal court supreme, right? Why? Well, Supremacy Clause. State judges and federal judges take the same oath to the Constitution. And a state judge and a federal district court judge are equally competent to interpret the Constitution in their own spheres. Now, is a state Supreme Court bound by U.S. Supreme Court judgments? Yes. If you are a state Supreme Court justice and you're acting in a judicial capacity, you are bound by the judgments of the U.S. Supreme Court. Why? Well, not in the Constitution, but we have a case called Martin versus Hunter's Lessee by Justice Story. And I think Justice Story got it right in Martin. It's not in the text, but I think Justice Story was right that the Supreme Court must have supervisory power over the lower courts. I'll accept that. Maybe that's a matter of text, but I'll give Justice Story the go-ahead on that one. I think he probably has a better argument, but it's not in the text. Now, question number 5. We're almost done here. Under Article 6 of the Constitution, state executive branch officials are bound by the decisions of the Supreme Court. And again, this is not a state executive branch official who sued as a binding judgment against him. Just a matter of course.
You're saying decisions, you mean precedents.
No, I said decisions. Okay.
But not when he's, but unless he's a party.
Yes. See, this is why Judge Pryor's not really a moderator. He's used to asking the questions, not sitting there passively, but I welcome the friendly amendment. What's the answer? Are executive branch officials bound in cases where they're not parties? Who thinks it's true? False? A lot more hands. So this is actually what can be known as the commandeering doctrine, perhaps in a slightly different fashion. We know that state judges are bound, right? State judges are bound by the supreme law of the land. And maybe that's the Supreme Court, maybe it's not. But here's the wrinkle. State judges have one set of duties. State executive branch cities have a different duty. Executive branch officials are bound to support the Constitution. Judges are bound to the Constitution itself. What's the difference between bound to the Constitution and being bound to support the Constitution? I don't exactly know the difference, but there's some difference between what executive branch officials do, Bill's shaking his head no, and what judges do. And the reason why, judges often have to apply state and federal law, and it makes more sense that judges would have a different duty. Okay? So those are the general points that I wanted to walk through. I think I have how much time do I have left?
None.
None. So let me give you the quick rundown, right? I haven't given you much about Roy Moore, but you probably know the gist of it. If the decisions of the U.S. Supreme Court are not the supreme law of the land, then state executive branch officials are not bound by it. The order with which Roy Moore got in trouble, I don't think he was acting in a judicial capacity. He was acting in administrative capacity as an executive branch officer of the state courts. I don't think he was bound in that capacity by Bergefell. Yeah, they probably agree. Yeah. I don't think in the capacity he was bound by Bergefell because he wasn't acting in a judicial capacity. Bergefell itself only concerned the marriage laws of 4 states, Michigan, Kentucky, Ohio, and Tennessee. Follow-up litigation resolved that. Indeed, after Bergefell, Grenade, right? Pronounce her name?
Yes.
Judge Grenade down in Mobile issued a preliminary injunction and said, hey, do not follow the state Supreme Court decision on Alabama Supreme Court because I'm telling you, you have to issue these licenses to gay couples. Okay? I think she was correct. Her decision was correct. The Alabama Supreme Court, though, didn't really get its act together. And I'm not an expert in Alabama procedure. My understanding is they never actually ruled on the issue. There was a big debate about what they did. In fact, they just basically dismissed the case or denied the petition, I forget the exact term of art. So as it stands now, you have a federal district court now in Mobile saying, permanent injunction, you have to issue these licenses. And you have a decision from the Alabama Supreme Court that was never actually vacated, as far as I can tell, that says you cannot issue these licenses. And this creates a very odd circumstance for probate judges here in Alabama. The odd circumstance is this. If they ignore the federal court, they'll be held in contempt in federal court, without question. If they ignore the Alabama court, absolutely nothing will happen to them. So the upshot is, the Alabama Supreme Court is not enforcing its own order. Not surprising, they don't want to. If anyone tried to bring a challenge, they'd have to rule along with Bergefell. But the very narrow issue, right? The very narrow issue is this. Bergefell did not take any action on the marriage laws of Alabama. A probate judge issued an order consistent with Alabama and domesticated that judgment, which was fine. She did the correct thing, I think, right? But there was still this dispute with this outstanding decision, okay? And as probate judges, even though their name is judge, they're acting in executive capacity. I think it's foolish for them to say, I'm going to ignore Bergefell and not issue the license, because they'll be sued and probably get 83 damages because they're clearly established law. But as a matter of judgment, not precedent, judgment, there was an obligation to do so. Now, I don't care about Roy Moore's ethics. I really have no interest in that. But the narrow point on which the Committee on the Judiciary ruled, where they said that a Bergefell is the supreme law of the land, I think that's wrong. And if a Bergefell is not the supreme law of the land, then I think the basis for the charges against him were not well founded. Now that's the second case. The first case that Judge Pryor was on is a different story altogether. In that case, there was a binding judgment against him. And for me, that makes all the world of a difference, right? If a federal judge says, we have an order against you, Judge Roy Moore, whether you're acting in an executive or judicial capacity, that is binding upon you. You have to follow it. So I think in the first case, the Ten Commandments case, Judge Roy Moore didn't have a leg to stand on. But in the second case, I think he actually had a credible defense under the Supremacy Clause. Thank you all so much. I will turn it over to Judge Carroll, and we can have a little bit of discussion later. Thank you.
First of all, I want to thank the Federalist Society for bringing this issue to the law school. I think it's important in these times that we engage in a respectful dialogue about important issues. And this certainly is an important issue, that is the relationship between the United States Supreme Court and state Supreme Courts and their decisions. Just to give you a little bit of a factual background so that you'll understand the Roy Moore case a little bit better. January of 2015, United States District Judge Jenny Grenade declares the Alabama state statute and constitutional provision that forbids same-sex marriage, strikes it down as unconstitutional. She has before it only the parties, which did not include all of the probate judges, included only the Mobile probate judge. As the case went on, she certified a plaintiff and defendant class so that all of the probate judges were there. Before the Obergefell decision comes down, after Judge Grenade has issued her injunction, then the Alabama Supreme Court in the API case says the laws of Alabama are constitutional. So you have a classic dilemma. You have a state court order, you have a federal court judge saying the law is unconstitutional, state court judges saying they're constitutional. But as Professor Blackman clearly said, and he's absolutely correct, state Supreme Courts are not required to follow the judgments of lower federal courts. Even Judge Breyer, if he issues an order, not required to do so. Only the United States Supreme Court. So things percolate along. In May, Judge Grenade issues a final preliminary injunction to all the probate judges in the state saying, you have to follow my order, you have to follow my order which says the Supreme Court opinion, which says that the state laws which forbid same-sex marriage are unconstitutional. But also, as part of that opinion, she says, you also may not follow the decision of the Alabama Supreme Court that says otherwise. And that becomes very important, maybe not to our debate, but just for your understanding of the case. June of 2015, the United States Supreme Court says, in Obergefell, same-sex marriage is constitutional. State laws that do not permit it are unconstitutional. And Justice Kennedy's language is, this ruling applies to all states. Doesn't say to all states that are before the court, to all states. At that point, Judge Grenade makes her injunction final. So at that point, there is a federal court order which says to the probate judges, you have to issue same-sex licenses. The case is then appealed to the 11th Circuit. The United States Court of Appeals for the 11th Circuit affirms Judge Grenade and says, Obergefell abrogates state court law to the contrary. So at that point, we have a United States Supreme Court saying same-sex marriages are valid in all states. You have a federal district court's injunction affirmed by the United States Court of Appeals for the 11th Circuit, which says probate judges have to issue same-sex licenses or they cannot refuse to. And that's where we are until January 2016, when Judge Moore issues his order saying to the probate judges, I hereby order you to follow state law. That is then followed by a decision of the Alabama Supreme Court that Judge clearly is correct, really didn't do much of anything other than let everybody have their say. So while the Supreme Court opinion is important to this discussion, the Court of Judiciary held, unanimously affirmed by a specially constituted Alabama Supreme Court, that Judge Moore also told the probate judges to violate a then existing, unappealed, and perfectly proper and enforceable injunction. Told them to do exactly what Judge Grenade said not to. So we're not going to talk about this case. But let's talk about Josh's thesis that a Supreme Court opinion only binds the parties that are before it. Obergefell, 8th Circuit. What does that mean? Well, first of all, it's contradicted completely by Cooper versus Aaron, which is the decision 70-some years ago by the United States Supreme Court, which says, look, once we decide a case, all states are required to follow that opinion. That's what the case says. It was the state of Arkansas said, wait a minute, that Brown versus the board thing, man, we don't have to follow that because it's Kansas and Delaware and those cases, not Arkansas. We don't have to follow it. In an interesting opinion, which all 8 justices signed, they said, no. Once we decide a matter, it's the law of the land. And it's very interesting, and this is sort of in the trial of the Court of the Judiciary, I cross-examined the Chief Justice. And one of our points of cross-examination, and it was true, that at the time he issued his order, the Supreme Court had decided Obergefell. The 11th Circuit, Judge Grenade had issued an injunction to all probate judges, which the 11th Circuit had affirmed. The probate judges who were before her said, we're going to follow Obergefell. The Attorney General of the state of Alabama, Luther Strange, said, yes, Obergefell is the law of the land. And I asked the Chief Justice, now, isn't it true that at the time when you issued this administrative order that the Attorney General, the Chief Law Enforcement Officer of the state, had said, Obergefell is the law of the land, and the Chief Justice snapped back at me, you tell me what the law of the land is. So I guess he was agreeing in some ways with Josh. But as presently constituted, yes, I agree 100% with Josh's textual analysis. Article 6 does not say that lower courts are bound by the quote-unquote decisions of the United States Supreme Court. But certainly Cooper versus Aaron says that. And that was what we argued to the Court of the Judiciary. The Court of the Judiciary agreed, as did the specially constituted Alabama Supreme Court. But think about the logical implications of Cooper versus Aaron doesn't mean that. You gotta wait till there's a judgment. Let's say Justice Kavanaugh goes on the United States Supreme Court. 3 years down the line, the court says abortion is now unconstitutional. It's got a case from Maine in front of it at the First Circuit. At that point, assuming that states don't want to follow that decision, they're not required to until somebody files suit, case wins its way up, and the Supreme Court decides the case. It's just, while I understand the argument, why create that inefficiency? Why make people jump all through those hoops? Because Cooper versus Aaron says that, look, once we decide a case, it binds everybody in the United States, not just those.
Okay. I'm going to suggest to the audience that both of them are wrong. So let me ask each of them some questions.
Oral arguments.
So let me ask you, Dean Carroll, if the decisions of the Supreme Court of the United States are truly the supreme law of the land, as the Supreme Court said in Cooper, I want to press you, is that really right? Because if that were true, then the Supreme Court could not overrule itself.
I think it's true, but I think the Supreme Court can overrule itself.
It can't overrule
Because
itself, though, if its decisions are the same thing as the Constitution itself.
I don't think that that's what Cooper says. The supreme law of the land means the law that all of the people in the United States have to follow, all the state officials have to follow.
But the problem with that argument is it not, is that if that were true, then everyone who acted contrary to Plessy and brought cases like Brown before the Supreme Court was operating on a contrary understanding of of what the Constitution says, and understood that Plessy was wrong and should be overruled, because it's the Constitution, the 14th Amendment itself, that's the supreme law, not what the Supreme Court says about it.
What I think Cooper says is the Supreme Court's interpretation of the Constitution is the supreme law of the land when it decides a constitutional matter.
It says that, but can that be true if the court has the power to overrule itself without amending the Constitution? That can't be true.
You and I would disagree.
How can it be that? If its decision is truly the supreme law of the land, what gives it the power to change the Constitution?
I guess it's power under Article 3.
All right, we'll look in the text for that provision. So my question for Josh is this, okay, all right, so I think Dean Carroll has correctly explained what happened in the second Roy Moore controversy with the same-sex marriage dispute. And the problem, it seems to me, for your argument, is that after the Supreme Court of the United States had ruled that same-sex marriage is required, that states cannot deny same-sex couples marriage licenses. After the Supreme Court ruled that in Obergefell, she then entered a permanent injunction against all the probate judges of Alabama. And Roy Moore issued an administrative order to them that purported to require them to violate a binding injunction against them. Sorry, so here's the hypothetical I will pose to you, okay? Let's say that you have school desegregation litigation going on in the 50s, 60s, 70s. The members of a local school board have all been made party defendants to the desegregation litigation. The federal district court has ordered that the schools be desegregated, has issued detailed orders about how desegregation is to occur, the time period for it to occur, and principals of schools in the school system who are not made parties to the decision, nevertheless refuse to do what the school board orders and refuse to comply with the federal district court's orders. Can they be held in contempt by the federal district court?
I think the answer is no. We've actually talked about this before, but let me give the facts of Cooper.
I mean, 50 years of federal court jurisprudence say otherwise.
We were arguing with Margaret in the car as well, so we go far back more than 50 years. Cooper arose in that exact capacity. So what happened? Who was Cooper? Who was Aaron? This was actually a lawsuit brought by African-American families in Little Rock against the school board. They got an injunction against the school board. Then the governor comes in with the National Guard and prevents African-American students from entering the building. You get an injunction against the National Guard. Then the state police come in, get an injunction against the state police. Then the local police, Little Rock police, come in. So the exact problem Judge Pryor is articulating is exactly what happened in Cooper. And the only way to resolve it is for people to voluntarily comply with precedent. Let me tell you something. After Brown, how many schools actually desegregated? The number is close to 0. After Cooper, how many schools voluntarily segregated? Close to integrated, right? The number is going to be strikingly small. Judicial orders that aren't going to be complied with people don't have much effect.
Yeah, but here's the question, okay? So let's say the principals in some of the schools don't comply with what the school board has been ordered to do. The federal district court, as a matter of well-established equity jurisprudence, can make those principals parties to it. It can add them as relief parties, and they don't get to relitigate the merits of the dispute. They are made parties for enforcement purposes only as state actors who are obliged then to obey the injunction. Isn't that right?
I know courts do it, and I know courts do it, and I'm sure there's case law saying it. As a matter of equity, it sounds fine. As a matter of Article 3, I don't see the basis. If you're not a party to a case, you haven't had a chance to litigate it, I find it troubling that you're bound by that judgment.
Where is that in the text?
Where is it in the text? You're trying to do something unorthodox,
No,
right?
what I'm explaining.
You're trying to say that someone who's been sued can now be the burden's on you, not me.
No. The point I'm making is you say that it may be that there's a lot of equity jurisprudence to support that, but you don't see it in the Constitution. But the Constitution's silent on it. It doesn't speak to it one way or another about what the remedial authority sitting for a federal district court sitting in equity would be once it has already adjudicated a matter involving state officials.
Well, no, I disagree.
Is there anything that
that you can point to that in the text of the Constitution that suggests that it overrides what has been longstanding with equity jurisprudence.
So federal courts are courts of limited jurisdiction. How do you get to federal court? Perhaps diversity, perhaps federal question, pursuant to Congress's statutes. Congress has to get to federal court, you have to sue a diverse party with matter of controversy, federal question. You have pleading standards, you have rules of procedure, you have to go through a complaint. There are various hurdles Congress has erected before you get to a judgment, and just adding a party in random total contempt, maybe it's a matter of equity, but has that fit?
That's actually contemplated in Rule 65 of the Federal Rules of Civil Procedure. There's plenty of not just case law, but rule authority about that very point. You can make relief parties to ongoing injunctions without having to file a new complaint against them and relitigate the merits of the dispute. So your argument is now a Federal Rule of Civil Procedure argument?
I actually, well, by the way, the Rules Enabling Act is probably unconstitutional. I think the Rules Enabling Act is a delegation of legislative power to the courts, that a guiding principle. I think it's actually entire federal rules. But anyway, that's either here or there. But don't ask a law professor who think that, I can be radical. But I think Judge Pryor's point is fair. Courts exercise a lot of equitable power to make sure that their judgments are not being interfered with.
Right.
They do that all the time.
Right.
And I'm not so concerned about that because it doesn't really implicate the Supremacy Clause. My concern is primarily the Supremacy Clause and rebuffing the notion that the court's judgments are the supreme law. Once a district judge domesticates the judgment against Roy Moore, or against a probate judge, against a probate judge, at that point I think the probate judge has a binding judgment against them. They ignore that at their own peril and be held in contempt.
And of course, the dispute with Roy Moore is whether he had violated the Alabama canons of judicial ethics. You say you're agnostic about it, you don't care about that, but that's why he was removed from office. And the argument was that his conduct, which was essentially could have subjected him to contempt proceedings, a point I don't hear you really disputing. It could have.
So you're saying Judge Grenade could have held Roy Moore in contempt?
Do you think that's not true?
She probably could have. If she, under the equitable principles that Judge Pryor articulated, if Judge Grenade thought that his order was subverting her judgment, she could probably rope to death Mobile and held in contempt.
And therefore, it would be perfectly reasonable for the Alabama Court of the Judiciary to rule that conduct by the sitting Chief Justice of Alabama is probably not in keeping with the canons of judicial ethics.
No argument there. I'm not giving any argument at this point. My point is far more narrow. There's one passage in the JIC and the COJ. I always get them confused. But there's one passage, with the COJ, where they basically say that the Obergefell decision invalidated laws in all 50 states, or whatever it was. That's me wrong. You're right. Justice Kennedy said all laws. But the last sentence is the judgment of the Sixth Circuit Court of Appeals, opinion by Judge Jeff Sutton, is hereby reversed. That is all the court did. They entered a judgment.
Just as a little bit of trivia out of this case, Judge Moore cited Cooper versus Aaron in the brief filed when Judge Pryor had the case, and he cited it as authority for the proposition he was.
Well, I don't hold it as a paragon of consistency,
But just one other point. I mean, no other court that I know of after Obergefell did anything. The Louisiana Supreme Court, for example, when the case came down, they said, look, case Obergefell moots what we got in front of us, case is over.
Well, that's technically because what Josh's point is about how we should really properly understand the Supremacy Clause is he's right about that, but your point about efficiency isn't a command of the Constitution. It's just the prudential judgment of government officials. Technically speaking, you could have the kind of massive resistance that you had in the Deep South during the
But I guess every court that I have ever seen, for example, there are at least 2 or 3 decisions of the Alabama Supreme Court which use the language, Supreme Court decisions are the law of the land.
They say that, but can it be true, John? Hear me out for a second, okay? So, when desegregation occurred, and the court decided Brown versus Board, and it said this applies to all the states, right? That did not mean, though, that if a school district that had never been made a party to a desegregation lawsuit had not desegregated, that they could automatically be held in contempt of court.
That's true.
What would have to happen is black school children had to sue them, had to prove in court that they were maintaining a segregated school system. The federal district court would be bound by precedent, the precedent of the Supreme Court in Brown, but it would have to actually be litigated on a case-by-case basis.
Unless the state voluntarily decided to desegregate.
Yes, exactly. But to the extent that any black school children felt that Brown wasn't being respected and that its interpretation of the Constitution wasn't being followed, that the non-parties would have that issue would have to be litigated on a case-by-case basis, right?
Yes.
Because Brown doesn't truly apply to them.
Yeah, which is, you know, what happened in Alabama's Grenades Injunction
Right.
was in existence at the time, and so.
Right.
But I guess so. Your thesis is, and I'll have to think about this for a while, that the Supreme Court opinion is you agree with the judge that you have to have a judgment.
Yeah.
Well, I agree with him. First of all, I think we're all in agreement
Yeah.
that decisions of the Supreme Court are binding precedent on all lower courts. In future
State
cases
and
or
federal.
controversies
State and
that
federal.
come before state and federal courts. We're all in agreement
I
about
think so,
that.
yeah, yeah, yeah.
Oh, yes, okay. That the Constitution means something when it says Supreme Court.
Yeah.
What I think Josh says, though, when he says decisions of the Supreme Court are not the supreme law of the land, what he means is they are interpretations of the Constitution that will be applied as precedent
Yeah.
in future cases that come before the court, but they are not the Constitution themselves.
Precedent, yeah,
And that's why the Supreme Court can overrule it. So
Yeah.
this was an argument Ed Meese made as Attorney General of the United States in the 1980s.
Yeah.
And it created a firestorm in national newspapers the next day. He gave a speech at Tulane University.
Yeah,
I was there. I published the speech in the Tulane Law Review when I was the editor of the Law Review. When we then invited legal scholars left and right, including folks like Bert Newborn at NYU, who had been president of the ACLU, to write a scholarly treatment and articles about what Meese had argued, they ended up, Mark Tushnet, for one, argued, well, technically, Sandy Levinson argued. Technically, he's right. They're not the supreme law of the land. The Supreme Court said,
Even though everybody calls them that.
Well, only
a
they
lot
do.
of lawyers.
Oh, one more pop quiz. One more pop quiz. Did Marbury versus Madison establish the proposition that decisions of the Supreme Court are the supreme law of the land? The answer is no. I have a new paper I call The Irrepressible Myth of Cooper v. Aaron, Georgetown Law Journal, coming out next year. And I went through all the papers of the justices who were there for Cooper. I went through all their papers, all their archived papers, and they struggled mildly. They tried to say that we're just doing what John Marshall did. This is just Marbury, and they couldn't make it right because Marbury said nothing of the sort. Judicial review, which I think we all agree is okay, is different than judicial supremacy. They're different concepts.
And if you read Marbury, what John Marshall wrote in Marbury was that the Constitution was supreme not only for the judicial, for the other departments of government, but for the judicial department as well. His argument was that the Constitution was supreme over all the departments. That it was an argument being made that, oh, well, he was basically using this for the sake of argument. Well, does the Constitution bind the Supreme Court? We know it binds Congress. We know it binds the President. And he points out there are provisions of the Constitution, for example, the provisions about treason, which contemplate court proceedings and contemplate that the Constitution itself is going to set the rule for those proceedings.
Let me ask you all a question and help me understand.
Yes.
So,
All right.
Supreme Court decides Obergefell. Kennedy says, applies to all states.
Yes.
A probate judge in Alabama, after Obergefell is decided,
Yeah.
and there's no federal injunction,
No federal injunction.
says, I refuse to issue a same-sex license.
Yes.
I then go to federal court and ask that he be held in contempt or sued for damages or whatever.
Well,
He's still accountable.
You can't
even-
hold him in contempt,
Right.
but you could sue him and
Right.
sue to enjoin him.
So
to
even though,
grant the
under
same
your
sort of
theory, the
right.
judgment does not apply to him, he's still accountable.
And just to be clear, a probate judge in the capacity of issuing a license is an executive branch official. It's not a judicial officer.
Right.
I think if
But
there
the
were
reason he's accountable is because,
subsequent.
well, the reason he's accountable is because that's, the argument is what the Constitution requires him to do so, right?
Right.
We can have an argument about whether that's a correct interpretation of the Constitution, but we know that if he's then sued in a federal court, the federal court is going to follow the precedent
Right.
of Bergefell.
And no qualified
But when
immunity.
all is said and done, he is not free to ignore that Supreme
He
Court.
can ignore being able to pay for it out of his own
There
pocket
you go.
because there's no
So-
qualified immunity.
So that's why I'm
Established law.
suggesting this is a
The
distinction without a
No,
difference.
it's important. The consequence is between a judgment and precedent. If he doesn't follow Bergefell's precedent, he's going with 1983 damages, and he'll have to pay out of his own pocket.
And part of the importance of the distinction, I would argue too, is that it's important to remember for purposes of overruling decisions of the Supreme Court that are wrong.
Mm-hmm.
The whole notion that the decisions of the Supreme Court are not the supreme law of the land, they are interpretations of the Constitution that bind lower courts, yes, but that the court itself is free to overrule if it becomes convinced that its interpretation is wrong. Why? Because it's the Constitution that's the supreme law for the land, not what the court says about it. It can conclude that it has been wrong.
So are we really saying you just don't like that language, supreme law of the land?
I think that language was an overstatement and is contrary to the text of Article 6.
I agree. I agree. Want to take some-
We may have persuaded him.
No. Again, I'm back to, it really is a distinction without a difference, which is the probate judge in Alabama is bound by that decision and has to pay out of his own pocket.
No,
if
no,
he
no, no,
denies
no,
it.
no. He's bound by a subsequent decision if there's a subsequent 1983 action. That he's bound by because it's against him directly.
But his
And
act,
he's
he gets
doing
in trouble.
something foolish if he doesn't respect the fact that that's the way it's
Right, he
going
gets
to
in
play
trouble
out
if
when
he doesn't
sues.
follow
That's
That's it.
Roy Moore 1 versus Roy Moore 2. That's the Ten Commandments case.
But ultimately, what will require him to issue the same-sex marriage license is the later decision that follows over.
This is a complete aside from what we're talking about, but in my closing argument in Roy Moore 2, I used the closing argument of Judge Pryor from Roy Moore 1. So, which was a damn good argument, by the way.
Thank you. I wish it had worked quite as well the second time as it did. Pretty good, pretty close. Questions?
Is Doug
from the
Jones
audience?
here? Any questions? No, I'm just kidding. Any questions?
I'm really kind of interested in, this has been a great exchange, I'm really interested in this theory. What do you all think?
Yes.
Judge Carroll, if the distinction is one without a difference, I can see your argument that it doesn't make a difference for executive branch officials or legislators or lower courts, but doesn't it make a big difference for Supreme Court justices, how they approach the law? I remember an NPR legal commentator talking about Justice Gorsuch complaining that he doesn't understand how the Supreme Court has amended the Constitution in the last few years. And
Yeah, I really will have to think more about this issue that Judge Pryor, which is if it really is the supreme law of the land, they can't change their mind. I have to think about that. It's very interesting. I think that's the first time I've heard it phrased that way. But I mean, the Supreme Court has always seemed free. I guess we're really not arguing because they agree that a probate judge who does not follow a Supreme Court opinion, there are consequences to that.
Right.
And so, I don't know, okay, maybe it's not quote unquote the supreme law of the land, but you violate what they say at your peril. So is that, I don't know. But it's very interesting.
Yes.
So, Judge Carroll, when you were talking about Cooper versus Aaron being the source of the Supreme Court's decisions being the supreme law of the land today, when Cooper versus Aaron was decided, or I guess the year before, what would the source of that, I guess, proposition come from? Because doesn't an institution's power have to come from some source that's exogenous to that institution. So where does that come from pre-Cooper versus Aaron?
You know, I think it came from courts interpreting Article 3, the Federal Rules of Civil Procedure, case law, that sort of thing. But I think Cooper versus Aaron portrayed it in that stark fashion, which was state of Arkansas clearly said, doesn't apply to us.
Of course, that was the first time the Supreme Court of the United States had ever said
Yeah,
that its decisions were the Supreme Court.
If you just Google the irrepressible myth of Cooper v. Aaron, I walked through the history, and they struggle. They cite a couple cases, Abelman versus Booth, Marbury, a few others. No case comes close to saying what they said in Cooper.
Yes.
Yeah, I was just going to make the point that, the thing that they relied on was Marbury. And it's clear if you read Marbury, it doesn't say even close to what the claimant says.
Right.
So it's really.
Yeah, that's right. They cited Marbury.
I mean,
And if you want to read about Marbury, then you need to Google
So I guess
the irrepressible myths of Marbury, which is something I ripped off the title. He ripped off the title.
under your theory, so what should the Supreme Court have said in Cooper versus Aaron? The state of Arkansas says, screw this decision, we're not following it.
They should resolve the case before them.
They should say, we were right in Brown. You're obliged to desegregate your schools because that's what the 14th Amendment requires. Period. Because that's what the 14th Amendment requires. Not because we say, not because whatever we say is the supreme law of the land, but because the 14th Amendment is the supreme law.
And the outcome is the same.
Exactly.
Yes.
The outcome would have been exactly the same, but that's just a bad precedent for us to talk about. And by the way, the courts never come back to Cooper to cite that proposition, not once. They've never relied on the proposition of judicial supremacy. They cited other parts of Cooper, but not that proposition. I think it's on very shaky footing. Anyway, it's got to come from somewhere. It's not Marbury.
Yes.
Logically following y'all's argument, I guess my question is more logic-centric rather than constitutional law and jurisprudence-centric. But following your argument, Judge Pryor, the two of you both agreed that the Constitution was the law of the land. And that's the one that governs us all.
Right.
Well, to Judge Carroll's point, if the Supreme Court is our highest form of court, our highest authority,
Right.
aren't they the ones that uphold the Constitution? And
No.
if so, aren't
No.
their decision the law?
No, see, remember that article that he put up on the screen that quoted Article 6? Who takes the oath? Do only judges take the oath? Everybody takes the oath. So members of Congress take the oath, members of state legislatures, governors, the president takes the oath. Everybody takes the oath. They're all bound by it. So they're all obliged to follow.
Bound what? Bound what?
By the Constitution.
That's not what it says.
Well, you're bound to support the Constitution. Now, you say that is, you're right, it's different phrasing, but you don't know what the difference is.
Scalia says there's a difference in print. There's a lot of fussiness in print.
Well,
That because state executive
about
officials...
commandeering. But it doesn't, it's not important for purpose of my argument. My point is, they're all bound by the oath to support the Constitution.
Agreed.
All then have the power to interpret the
Agreed.
Constitution.
Amen.
And in times, there are times when if officials of other branches of government can interpret the Constitution in a way contrary to the way the Supreme Court has decided it. And guess who has the last word? Not the Supreme Court. The Supreme Court is not always the final word on the Constitution. And I'll prove it with an example, an ancient example. The Supreme Court and the federal courts ruled that the National Bank of the United States was constitutional. Big argument at the beginning of our country, at the beginning of our republic. Andrew Jackson believed very strongly that it was not. Congress passed a law reauthorizing the Bank of the United States. What happened? Andrew Jackson vetoed it. On what ground? That it was unconstitutional.
He said it wasn't necessary.
Necessary within the meaning of necessary.
The facts had changed and made it no longer necessary.
Yeah,
But I agree with the general premise.
But there are plenty of veto messages from the early republic where, for example, Thomas Jefferson pardoned individuals who had been convicted under the Sedition Act and ordered his prosecutors not to prosecute anyone for violating the Sedition Act. Even though the federal courts it upheld the Sedition Act, contrary to the First Amendment. Thomas Jefferson was right about the First Amendment, the federal courts were wrong. But at the end of the day, who had the final word? Thomas Jefferson had the final word. There are many examples in our constitutional history where executive or legislative officials don't respect what the Supreme Court has said, act contrary to it, and actually have the final word because the Supreme Court's not the final word on the Constitution.
Question over there?
So what it sounds to me like you may be saying is just kind of manifested itself in this question over Judge Moore. And correct me if I'm wrong, but would your position be that the Supreme Court of the United States has essentially, by its own rulings, made itself too powerful? And then I guess my follow-up question would be, so are you insinuating that we really need to do something, or something should be done to kind of take the teeth away from the Supreme Court in some way? And that the only thing, I guess, would your argument be too that the Supreme Court isn't saving us from really anything except themselves?
Yeah, he's not going to answer that one. I'll spare the good judge and the Nelson team. Has the Supreme Court gone beyond its original function? Probably. What can be done to stop it? I don't know. To be frank, I think what will probably try and stop the Supreme Court's current trajectory is not people like me, but people who are mad about Brett Kavanaugh and Neil Gorsuch, and we'll have court packing in a couple of years. And then once it happens, of course, it will change. So I don't think there will be any rejection of the notion of judicial review. I think people still have the idea that the Supreme Court decides disputes. I mean, think of Bush v. Gore, right? After Bush v. Gore, Al Gore said, okay, the court's spoken, I'm going home. He didn't say, let's mount a militia and let's go storm D.C., right? That wasn't a thing. So I go with Dean Carroll. There's an advantage to having one body to give the final word. Now, you might like the decision. You might be a George Bush fan. Yay, go Supreme Court. And if you're an Al Gore fan, you think, boo. Why should it be that one man, let's just call him Tony, can decide every major issue of significance for the last 30 years? Yeah, I mean, no one man should have all that power. It's wrong. It's not a correct application of anything.
But you said a moment ago that since Cooper versus Aaron, the Supreme Court has never said anything really close to that again.
No, they haven't. And even though they said all states, the last line was the judgment of the Sixth Circuit's reversed. So they still acknowledge the limited
And
scope.
you acknowledge that as recently as Bush versus Gore, Al Gore, who was a party to the decision,
Yeah,
right?
yeah, he was bound. Yeah.
Respected the decision of the Supreme Court, right?
Yeah, yeah.
Right?
I do worry what would happen if there's a big case with President Trump and the court rules against him. I do, like after the travel ban, he was like, "Wow, I won," So just TBD.
Could you guys explain the difference between the Alabama case on the Ten Commandments and the Texas case on the Ten Commandments, and kind of how that?
What a good question.
Well, yeah, I'll be happy to touch that. I mean, so in Texas, there is a monument of the Ten Commandments. It was placed there, I think, in the 50s by a group called the Fraternal Order of Eagles. They place monuments like that out on courthouse and similar government building kinds of grounds around the country. In fact, I think the release of the movie,
Ten Commandments,
the Ten Commandments movie, Cecil B. DeMille's movie, kind of spurred this movement. And the Supreme Court of the United States ruled that monument was placed there a long time ago for purposes that could not be called necessarily religious in a way that would violate the Establishment Clause of the Constitution. Okay. Roy Moore, on the other hand, after he became Chief Justice, constructed a 2-ton monument of the Ten Commandments, placed it in the rotunda of the Alabama Judicial Building, without telling anybody else, including the Associate Justices.
At night, right?
Yes, at night. Had a religious ministry, Coral Ridge Ministries, come in and film it as it was taking place, and then was sued for having violated the Establishment Clause. And I would say, you can go back and look at the case yourself, made what I think many would say were unorthodox arguments about why he was permitted to do that, and arguments that were clearly inconsistent with federal case law at the time. He did not make the kinds of arguments that have been made out in Texas of we can satisfy the existing case law. And as a result, that the inevitable result of it, the kinds of arguments he was insisting on making was that he was going to lose that case. But that's different from what led to his removal. After an injunction was entered against him, a permanent injunction, and he refused to obey the injunction, a charging body created by the Alabama Constitution called the Judicial Inquiry Commission brought charges of judicial misconduct against him for flouting a final court order that had been entered against him as a party to the case, and said that violated the canons of judicial ethics, and I prosecuted him in the Alabama Court of the Judiciary, and that court removed him from office.
Are we done?
We're done.
Thank you all.
Thank you, this is good.
Anyone who's interested in the Federalist Society and becoming a member, we're going to take some stuff outside.